Aboriginal communities are more likely to become active in the energy sector as proponents, not just as parties who are being consulted with. One of the main reasons for this is that government policy and the state of the law in Canada, frankly, is converging to create a situation where this is doable for First Nations and Aboriginal communities generally. The different types of facilities that Aboriginal communities might become involved in the development of range from solar energy development, wind turbines, hydroelectric facilities, and other types of energy generation. It really is going to depend a little bit on what the First Nation or Aboriginal community is closest to. Some of the issues that Aboriginal communities are going to have as they try to develop energy generation or transmission facilities are going to be unique to them. This is mainly because they don't have the same kind of capacity, both from a financial and human resources point of view, that other entities do have, whether they be government or private sector entities. Aboriginal communities are going to have to reach out and seek that kind of support, but they're going to need special assistance that only consultants and lawyers and accountants with that kind of experience can provide. We at BLG actually are quite involved in the provision of legal services to Aboriginal communities and also to those other non-Aboriginal entities that are active in the sector, especially where we're seeing energy and Aboriginal interests converge. In the past decade or so, the legal requirements to engage Aboriginal communities has changed dramatically. Governments who bear the brunt of this and the principal responsibility for consulting with Aboriginal communities have been told by the Supreme Court of Canada and others that they have to consult on activities where treaty or Aboriginal rights will be affected by an activity that the government proposes to undertake. Activities that the government might take could include things like building things, that is the government building things, or it could be simply a situation where the government is granting an approval for something to be built by somebody else. This is an interesting situation because actually when that happens, it's not just the government that has to do the consulting, but you actually have a situation where the private entity that is trying to build any particular energy facility has to become involved in the process. Sometimes this means that they actually undertake the consultation themselves. Sometimes it means that they work with the government to consult the Aboriginal communities. But either way, those requirements are far more significant now than they were 5, 10, 15 years ago. The changes to the Federal Environmental Assessment Act are quite controversial. They are big changes, and there is a big difference in the way environmental assessment is undertaken now at the federal level. While the environmental assessment requirements may be reduced, it's worth noting that the constitutional requirements to consult Aboriginal communities, whether you're the Crown or a private entity, have not changed. So even though we have an Environmental Assessment Act that is more streamlined, that should result in quicker environmental assessment, in many cases less of a requirement to conduct an environmental assessment, the changes to the federal environmental assessment legislation won't have an impact on the constitutionally protected rights of Aboriginal communities to be consulted. But they will have an impact on the way they're consulted. Right now, Aboriginal communities are consulted principally through the environmental assessment process. And that might mean that the proponent of a project, whether they're private sector or the government or some other proponent, has to find a way of engaging with the Aboriginal communities outside the environmental assessment process. And that could be a challenge. Around the country, there are several places where there are modern land claims that have been negotiated and where treaties have been entered into in recent times. The question is whether that changes anything with respect to the Aboriginal community's rights to be consulted. The reality is it doesn't change much. Aboriginal communities still have the constitutionally protected rights to be consulted about things that will impact on their treaty rights or their Aboriginal rights. But in the case of modern treaties, there is actually a treaty and rights related to it that they have to be consulted with respect to. So although it may seem strange that Aboriginal communities have to be consulted where treaties have been recently signed, it actually makes a lot of sense because what's constitutionally protected in Canada is the rights of the Aboriginal communities to be consulted about their treaty rights. It doesn't matter if the treaty is new or old, those rights are still there and they need to be protected. But it is an area that's continuing to change, and we at BLG are watching the changes. We're involved across the country, both with courts, with tribunals, with transactions that are involved in these various different areas. And it's safe to say that our energy group in particular, our Aboriginal group as well, and the practice as it relates to environmental assessment here at BLG is very active. We have a number of lawyers across the country at our various different offices who are very active in this area and continue to stay on top of these issues so that when they do come up, we're ready to provide the assistance that people need, whether they're Aboriginal or private sector developers or come from government for that matter.